ต้องเหมือนงานเข้าแล้วเนี่ย
อะไรคะ
Google บอกว่าคาดว่าฝนจะตกในเวลา 16 นาฬิกาเพื่อสาย
Okay. Does everyone hear me? Okay, that's good. We're going to start now. Um, Good afternoon from Bangkok. Thank you for joining us in this webinar series 2020, organized by Thailand Arbitration Center. Today we will have a discussion on the seminar series is called Paving the Way for Effective Use of ADR in Commercial and Investment Disputes. And here is a session 3, managing intellectual property dispute through ADR. So we would have about 2 hours, and I will be the moderator. This session will aim to look at whether how the dispute, IP means intellectual property disputes, could be resolved by using the alternative dispute resolution in solving the IP disputes. We have 3 perspectives coming from different organizations, but all of them are involving in intellectual properties. First, we would have Ms. Chiara Accornero, who is the legal officer of the World Intellectual Property Organization Arbitration and Mediation Center, who is now based in Singapore. Welcome. Thank you for joining us, Chiara. And the second, we have Kun Vaowdao Damrongphol, who is the Director of Legal Affairs Office of the Department of Intellectual Properties, or the DIP. Kun Vaowdao is the senior legal Thai government officials who was been involved in the IP issues, including IP disputes and dispute resolutions for a very, very long time. Kun Vaowdao will reflect on the issue of how IP dispute has been resolved by using the ADR from the Thai government perspective. We also have the private practitioners, Michelle Ray Jones, who is the consultant of the renowned Gibbons International, based in Bangkok. Gibbons is well known for its expertise in IP disputes and IP enforcement in particular. So I will invite Chiara to speak first. From her experience, from her job, her duties, working for the World Intellectual Property Organization, how the IP dispute can be resolved, looking from the international perspective. We would have about, in fact, we have 30 minutes for each speakers, but we would allocate time to each speaker for about approximately 15 to 20 minutes, and then reserve 20 minutes for Q&A. If you are ready, Chiara, may I invite, the floor is yours. Thank you.
Thank you very much for the introduction, and good afternoon, everyone. I hope you can all hear me well, and hopefully now you will also be able to see my screen and my slides. So my name is Chiara Accornero, and I am the representative of the WIPO Arbitration and Mediation Center in Singapore, where I am based. So actually the topic for this session is managing IP disputes through alternative dispute resolution. And this is something that has been done at WIPO since 1994 when the WIPO Arbitration and Mediation Center was established. So what I would like to do in the next minutes is to share our experience dealing with intellectual property disputes. Basically, we offer mediation and arbitration services. And also I would actually like to share one specific case. It's a very recent case to really show how these procedures work in practice. And it's also one case, it's a trademark one involving one party from Thailand. So I thought that could also be of interest. Now, before we actually start, with WIPO. So these are some of the reasons why, in fact, the WIPO Center was established and why alternative dispute resolution mechanisms, so mediation, arbitration, actually have some advantages for IP disputes. So cost and time are, of course, some of the primary considerations. And that's true for all disputes. Time and cost are always important, but even more for intellectual property disputes. For example, time is of the essence. And this is because in IP, there is often a very short product and market cycle. So time is of the essence. And generally, mediation and arbitration are procedures that are faster and cheaper than court litigation. Now, to give you really a practical example, the case I'm going to present later, and I was telling you, was a multi-jurisdictional case, so a very complex case involving 6 jurisdictions, and that was mediated at WIPO. So it was a WIPO mediation, and it took 4 months. There was 1 day mediation meeting, and the total cost of the case was 11,000 Singapore dollars, which is around 8,000 US dollars, which is usually split 50-50 by the party. So mediation specifically, but arbitration as well, can be cheaper and much faster than litigation in most countries. So time and cost. Then, of course, there is the expertise. IP disputes are very often very specific, so that they can also involve some technical issues. And you know, it may be the case that you have in a national court a judge who is experienced in IP disputes, has got some specific knowledge, but it also may be the case that they do not. And the advantage here of mediation and arbitration is that parties can actually choose, they can select the mediator or the arbitrator. And they can also select someone, some specific expertise in intellectual property. So for example, at WIPO, we have a network of now more than 2,000 mediators, experts, arbitrators that can be appointed by the parties. And all these persons have some specific knowledge of intellectual property. So expertise is another factor. And then something that we hear from parties is very often a primary consideration is confidentiality. So as you know, in court litigation, usually the proceedings are public, but very often, and specifically in intellectual property disputes, parties sometimes have an interest in keeping the dispute confidential, private. And that can be the case, for example, because you have some confidential information or trade secrets at stake, but also, and we see that quite often, for example, with startups, they also would like to keep the dispute private for reputational reasons. So imagine, for example, a startup in the field of fintech that does not want to dispute to be public, because otherwise that could be it could be harder for them to get investments. So confidentiality is also another consideration, and both mediation and arbitration are private procedures. And especially under the WIPO rules, we have a very specific confidentiality code whereby the mediation, the arbitration, everything basically that happens within the procedures is kept confidential. A couple more aspects. One is that very often intellectual property, and so also intellectual property disputes, have an international dimension. So they actually involve different jurisdictions. Because, for example, intellectual property is protected in different jurisdictions. Now, just imagine how costly, how time-consuming it would be to litigate the intellectual property in all those jurisdictions. And then maybe you would have also some inconsistent decisions, and then you would have to enforce all those decisions in all the countries involved. Now, with mediation, arbitration, you can actually have one single procedure that resolves all the disputes in all different countries. And also in terms of enforcement, with the New York Convention for arbitration, and now with the Singapore Convention, which will enter into force in September, also for mediation settlement agreements, the enforcement side is also much easier. So also having a cross-border solution is another big advantage for IP disputes. And then, and this is particularly true for mediation. Mediation, there is not a decision from a judge, from an arbitrator, from the mediator. The mediator does not decide. The mediator helps the parties reaching a solution. So the nature of the procedure is less adversarial. It's much more collaborative. And this is something that we've actually seen in practice. When the parties manage to settle for mediation, sometimes this also helps, and they also manage to maintain the business relationship. So not only the dispute is resolved, usually in a confidential way, in a much faster and cheaper way, but also it goes beyond the dispute. The parties are able to continue and go on with their business relationship. So time, cost, expertise, confidentiality, the international aspect, and also the collaborative nature of mediation are some of the reasons for which alternative dispute resolution, in particular mediation, but also arbitration, can actually be very suitable for intellectual property disputes. Now, going back to WIPO, first things first, what is WIPO? What does WIPO do? WIPO stands for the World Intellectual Property Organization, and it's an agency of the United Nations. It's an agency which is specialized in intellectual property, and then basically the mandate of WIPO is to promote innovation and creativity for the development of all countries through an effective and balanced IP system. So what does this mean? What do we do? We have some services. Maybe you're already familiar with some of them, and maybe you've actually used some of them. For example, for the the international registration of trademarks, of patents, of designs. Now, another service which is offered by WIPO is the resolution of intellectual property and technology disputes through alternative dispute resolution, mediation, arbitration, and that's what we do at the WIPO Center. Our the purpose and the reason why the WIPO Center was actually established is to really limit the impact that disputes have on businesses. And the way we do it is through mediation and arbitration. So we facilitate the resolution of these disputes between private parties. So we're not talking about state-related disputes, but it's private commercial disputes. We have one main office, headquarters in Geneva, and then the WIPO Arbitration Mediation Center also has an external office in Singapore. So where I'm based, but really this does not mean that to have a mediation or an arbitration of WIPO, you have to come to Singapore or go all the way to Geneva. So parties are free to have their mediation, arbitration everywhere in the world, really anywhere. Including in Thailand, and also they can do so online. So the last cases that we had were actually held completely online, so with no need to travel even. And I think that there's a couple of features that make the WIPO Center a bit particular. And this is because we're part of the World Intellectual Property Organization. The first one is that we are neutral. So this means that we have no connection, no link whatsoever with any jurisdiction, any country, any law, any language. And this is something that maybe for domestic disputes is not very relevant, but if you're dealing with an international dispute, so imagine you have one party from Thailand and one from, say, China. Of course, the Chinese party may want to drag you to the Chinese courts or to a Chinese ADR institution, but being from Thailand, coming from a different set of laws and jurisdiction, that may not be your interest. So having a neutral forum, and WIPO has got this neutrality, is actually an advantage for both parties and may be acceptable to both parties. So neutrality is one, and the other sort of special feature is that we're really specialized in intellectual property, and again, that's because we're part of WIPO. We have this database, this list of experts in all fields of IP and technology, and not only, also in some specific, say, technology-related industries. So, for example, I mentioned fintech, that can be appointed in WIPO cases. And this is very important, again, because intellectual property disputes can be very technical, very specific, but also having someone that has an understanding of the business of the industry, so say that the fintech industry, is actually a big advantage, because maybe in a mediation it can help parties get a better outcome. So the specialization is another one. Well, we're not for profit, so we try to keep our fees as low as we can. And this is also because, of course, we deal with multinational companies, but not just that. We also, our cases also involve some SMEs, some startups, say inventors, artists. And what we do is we always try to tailor the cost, for example, the mediation fees, the mediator's fees, the arbitrator's fees, to the specific case. And it's also something that we do in our administration. We negotiate the fees to make it really fit for the case. We have different ADR services, but I would say the ones which are used the most are mediation and arbitration. So in practice, what do we do? Well, even before a case is filed with us, we provide procedural advice. So for example, if you are negotiating a contract with the other party and you are inserting a dispute resolution clause, or mediation clause, and arbitration clause, we can actually help. So for example, this is a model clause. We have model clauses on our website that you can use. You can just include them in your contract. This is a WIPO mediation clause followed by expedited arbitration, but you can also come to us, email us, call us, and we can actually give you procedural guidance on how a clause should be drafted. We can review also the clause for you, and this is something that we do, for example, free of charge, of course. Or for example, if you are involved in a dispute, you would like to start mediation, but say you don't have a contract because it's an infringement, or you don't have a mediation clause, we can also help you submit a dispute to WIPO. For example, in the case of mediation, you can also submit a dispute unilaterally. So this is just a form that you have to submit to WIPO with a few information on the other party and dispute. And then we can also help you get in touch with the other party and explain how mediation works. And if the other party agrees, they will also sign the document and the mediation will start. So this is all part of our sort of procedural assistance that we do even before a case is filed with us. So if you're involved in a dispute, drafting a contract, just get in touch with us and we can see what we can do to help. Then once a case, a mediation or arbitration is filed with WIPO, we administer the case. So basically, we make sure the case is on track, we facilitate communications, we enforce timelines. We also have some free online video conferencing services or platforms that you can use. What I think is really crucial about our role when we administer cases is that we help parties choosing the mediator or the arbitrator. And that's important in all cases, but even more in IP cases that can be so specific. It's really the quality of the mediator or the arbitrator that makes the quality of the mediation of the arbitration. And when we do so, of course, we have this database with many experts, but we also try to get the parties' feedback as much as we can. And we're going to see in the case how we do that in practice. Now, this is our settlement rate. So this means if you look at the green one, WIPO mediation, that in 70% of our cases parties settle. So this is a quite high settlement rate. And really what we see in practice is that when the parties settle, sometimes in mediation, this goes beyond resolving dispute, in the sense that they are actually able to continue the collaboration. So for example, very often it happens that during the mediation meeting, the parties, they settle, they resolve the disputes, but they also renegotiate the terms of the collaboration. And very often it's to continue the collaboration. And even in arbitration, where actually, I mean, in arbitration, there is a decision from the arbitrator. So you're not looking for a settlement, really, you're looking for a favorable arbitral award. Even in arbitration, sometimes parties find an opportunity to settle. So this is just to say that there is plenty of opportunity for settlement, clearly in mediation, but even in arbitration. And where the parties settle is of course the best scenario because it's the parties' decision. Now, this is the case I was mentioning to you. It's a trademark case, and it was an international case involving one party from Thailand. It was a Thai businessman and a company from the United States. So the dispute was about some, I think it was either 3 or 4 trademark oppositions that were pending before the Intellectual Property Office of Singapore. So one of the 2 parties tried registering the trademark and the other party opposed. So the parties decided to actually, instead of going ahead with the IPOS trademark opposition proceedings, to try and mediate the case. So the case was submitted to us, to WIPO. Now, we, to appoint the mediator, we actually spoke with both parties separately, and we asked them if they had some particular, requirements they wanted from the mediator. And they said that they wanted someone which has some extensive mediation experience, so an experienced mediator, and also with some specific knowledge in trademark law. So we proposed 5 candidates to the parties, and the parties there either agree on one candidate or they rank them. In that case, they agreed on one candidate. So we appointed a mediator that was experienced in trademarks. Now, this was quite interesting because then the mediator got in touch with the parties to, organize a mediation meeting, the case file and all. But during these calls, the parties actually said, oh, we actually also have the same dispute pending in a few other countries. We have it in Thailand, in the Philippines. Can we also resolve that one in this mediation in Singapore? And the mediator said, okay. And then they'll say, oh, but we also have the one in Indonesia and another one in the Philippines. So both parties actually decided to resolve all their pending disputes in that one mediation proceeding in Singapore. There was a one-day mediation session from the morning until quite late at night, but the parties managed to solve all the disputes in all jurisdictions during that mediation meeting. So the total duration of the mediation since the request was filed was 4 months. The cost I checked just now, it was $8,000 US. The parties were also able to benefit from some funding scheme from the IP office of Singapore. And most importantly, they really managed through one day of mediation to resolve all cross-border disputes they had in all these jurisdictions. So this is really to show how mediation can work in practice and can be a quite a very effective way of managing intellectual property disputes. So with this, I would be happy to take any questions, either now or at the end of the presentations.
Okay, thank you, Chiara. It's very comprehensive, and I think it's a very detailed, comprehensive presentation. And we now seem to have a clear picture about how WIPO Arbitration Center is working. I think from my understanding is that it seems like WIPO is doing quite well in terms of providing the alternative dispute resolution for cross-border IP disputes. Because in your examples that you raised, most of the parties are from different nationalities and seems to have the disputes. Then I will, maybe I will give you some kind of question. Maybe you come back and in the next round you clarify. Maybe we need to elaborate as to the types of IP disputes that may be suitable for this sort of ADRs. For example, would it be suitable for infringement of IP disputes? What about misappropriation of business goodwill, trademark, reputation, and also breach of confidence like trade secret, compared to the litigations environment that is done in court? And also, what about the unfair competition disputes? Would this be suitable for this sort of IP disputes? Maybe you don't have to answer now, but there is also a question to you. Maybe you can have a look at your screen, and also next round I will invite you to address these questions. For now, thank you very much, Chiara. May I move to another speaker? We have Kun Vaowdao from the DIP. Kun Vaowdao is a legal director of the DIP, so that means that she's been involved in IP disputes and IP enforcement in Thailand. I think she's also participates in international collaborations in IP matters. Kun Vaowdao will address us about how IP disputes has been resolved outside the judiciary sectors in Thailand, particularly how her organization has helped the Thai IP owners and also the alleged infringer to resolve their disputes. May I invite you, Kun Vaowdao. Thank you very much.
Thank you very much, Dr. Jakkrit, for introducing me. And today I will talk about the IP dispute resolution of Department of Intellectual Property of the Ministry of Commerce of Thailand. First of all, I would like to talk about the history of the system of DIP to facilitate intellectual property disputes and intellectual property related disputes. The Ministry of Commerce of Thailand issues 2 regulations, which are first the regulation of mediating dispute related to intellectual property, and the second one is the regulation of arbitration related to intellectual property. Since intellectual property related dispute cases increases more and more every year, it slows down our economic development. Therefore, the Ministry of Commerce issues these 2 regulations to reduce the number of IP litigation cases to the court. It is an impartially effective process and less time consuming. At the Department of Intellectual Property, we settle the IP, all kind of IP disputes, including patent, trademark, copyright, layout, designs of integrated circuit, trade secret, geographical indication, trade name, plant variety, and IP-related disputes, such as domain name or the dispute over the social media. This is the statistics of IP-related dispute cases at DIP from the year 2002, which is the year that we started ADR process at the DIP. We have total 607 cases came into our mediation process. The majority of the cases are copyright, which has a total number of 361 cases. This is count for 59% of the total. And the second one is the trademark cases, which the number of 176 cases count for 29% of the total. And the third one is patent, and the lastly is trade secret cases. As you can see in the statistics, we have a lot number of successful mediation cases. However, we also have unsuccessful mediation cases. Why? The reason that we have the unsuccessful mediation are first, due to the mediation of the DIP is a voluntary process. So if the disputant does not want to enter into mediation process, the mediation cannot happen. The second one is both parties cannot reach the conclusions that satisfy both needs. Sometimes, no matter how many times we talk the needs of both parties, grew apart beyond the point that they can have a satisfying conclusion. And the third one is both parties enter into the process because it is stipulated in the contract that they have to go through the mediation process before starting the lawsuit. But the parties have no real intention to reach an agreement. And the last reason is the details of the cases that the party wants to resolve is not about IP, so it is not the jurisdiction of our department. This is the beneficial of the mediation process. Why we use mediation process? For the mediation at the DIP, it is free of charge. And the second one is any facts that revealed during the process of mediation will be kept secret. And the third one is the parties can still file for other legal actions, such as a complaint to the police or a lawsuit. And the last one is it is on a voluntary basis. So the mediation can start and stop at any time. Both parties can decide not to participate in mediation process at point. For the process of DIP mediation, if someone would like to request for the mediation process at the DIP, he has to file the tendering request and to the Director General of the Department of Intellectual Property. And the tendering request need to consist of the information such as the right to the intellectual property or related matters, the request for mediation with whom and on what grounds, the name and information from both parties, and of course, the facts of the dispute. After the DIP received the tendering request, the process will begin. The procedural steps of the mediation after the DIP receive the tendering request, DIP will conduct an investigation on the request for mediation, including facts, legal provisions, and any relevant decisions to decide the expert attending the meeting, and also the means of mediating to achieve success. Then we will invite the requesting party to provide the facts and claims. After that, we will invite the disputant to understand facts and claims for consideration. In these steps, the disputant may claim or use other means in order to cease the dispute. And the last step, we will invite both parties to mediate together, to negotiate and to modify the agreement in order to create reasonableness according to the needs for both parties. Let's move on the things that the Department of Intellectual Property will do next to improve our ADR process. The first one is improving the arbitration process by updating the two regulations issued by the Ministry of Commerce to accommodate the needs of the parties and improve the usability according to the current economic and social development. Second one is training and coaching the ADR personnel to increase their capability of handling the more difficult and complex disputes. And the third one, developed partnership with ADR institutions in Thailand, such as Thailand Network Information Center or THNIC, and international organizations such as WIPO, to explore possibility of partnership, such as signing an MOU to facilitate disputes related to domain name. The fourth one is extend the scope of ADR to the online dispute resolution. And the fifth is monitor the development of related laws in Thailand. The mediation law just came into force in the year 2019, last year. So we have to explore that important law to understand the effect it has toward the DIP mediation process and monitor closely any rules and regulation issues with regards to the law to improve our process of mediation. And the last one that we will do, develop the procedure to support ADR by gathering the records of disputes to facilitate the search and the connection between the disputes and other related information, and promote the use of ADR. Thank you.
Okay, thank you very much, Kun Vaowdao. That's very comprehensive and very good presentation. Thanks for that. We have found that the DIP, the Thai government Ministry of Commerce, have been very successful in terms of establishing the procedures that the parties of the IP rights can resolve their disputes outside the court system. And I think the number of 607 cases for the past 18 years. I'm not sure whether this is a good case, this is a good number compared to the court cases. However, it seems like many parties decided to go through the ADRs run by the DIP. Perhaps one of the reasons would be it is offered free of charge. And but I think in order to convince the party to go to the ADR, either WIPO or the Thai governments or any government agencies, you would need to provide more than that. I think more than the cost, the speed, you would also need the efficiency to prove that go to the ADR system will be more efficient compared to the litigation process. The specialization of the arbitrators, for example, not only the expertise and specialization in IP law, but also in technical matters in certain cases, because as you may know that the IP disputes would involve solving the issues surrounding the technical matters. And I think the ADR has to provide that. We have found that WIPO has done quite well and it attracts a lot of interest. And also the Thai government are also doing quite well as well in terms of attracting the parties to go to that channel. Now we will turn our attention to the user. We have the two providers already, one international, the other one is a government national levels. Now we would have Michelle Ray Jones, who's a private practitioner with Turkey and Gibbons. Michelle will tell us about her experience, whether she has used the ADR at either WIPO or the Thai the DIP. May invite you to speak. You have about 20 minutes. Michelle, please.
Sure. Thank you, Dr. Jakkrit. And thank you, Chiara, and thank you, Kun Vaowdao. It's very nice listening to you. As Dr. Jakkrit mentioned, I will speak from a practitioner's perspective and talk about some of the ADR that I have been involved with. So let me just bring up my slides here. Okay, let's see. All right, let me make this. Okay, so one moment while this loads. Is it showing as the full screen for you? I don't think so. Okay, there we go. All right, so I'm going to go through some example cases. These are all made up cases, but based on real life situations, where in my practice, I've helped clients choose between ADR and taking a matter to the court. So the first case I want to talk about involves a hotel. Let's pretend that we have a client who is located in Thailand. They decide to open something called the Orion Hotel. They do their, their legal homework, and they are able to register the trademark Orion Hotel. And they also buy the domain name orionhotel.com. Now everything's going well. They're making bookings through their domain name on their website. And then after about a year or so, they notice a drop off in direct bookings through the website. And then they do some Googling and they find that someone else has registered the domain names orionhotel.net and orionhotel.com, where the I has been replaced with a Y, and that when someone goes to these websites, they see websites that look very much like the real orionhotel.com website. And on those websites, you can book rooms at the Orion Hotel. So it's helping people book rooms through there. And they also offer similar hotels in the area for people to choose from, and also have some ads up there. So they're making money off of their website. So what do? We could tell the client that they could try to go after this domain name in court. But what we normally recommend is that they take an action involving ADR. So how do we get to ADR in this situation? So when registering a domain name, the registrant, so here that would be the infringer, the person who has registered the orionhotel.net and then the typo of orionhotel.com, the registrant agrees to follow the ADR policy relating to third-party IP claims that are in the terms of service of the registrar. So the domain name registrar would be someone like GoDaddy or one of those other companies where you purchase your domain name. And when you sign up for your terms of service, there you have a requirement that you go through ADR if someone else claims that you're infringing their IP with your domain name. So often the ADR policy in the terms of service will tell you that you need to use the Uniform Domain Name Dispute Resolution Policy, known as the UDRP. So let's talk about the UDRP. So there are multiple different policies, but the UDRP is one of the biggest, most widely used policies. As you can see from this list, this policy covers many different types of domains, .coms, .nets, .orgs, .info. There's many different domain names. These are top level domain names that are covered by the UDRP. Now you may be familiar with lots of different types of domain names like country code, top level domain names like .co.uk or .co.th. So for each individual case involving a domain name, we need to ascertain whether it falls under the UDRP policy or under another policy, and then go from there. But in most cases, the domain name will fall under the UDRP policy. And once we ascertain this, then we can decide on an ADR service provider who will handle this domain name dispute. So as you can see, the first one there is WIPO. We often recommend that clients use WIPO. They're long established in doing the UDRP cases. They're very good at that. Another one that's very popular is called the Forum. It used to be called the National Arbitration Forum. Now they're just going by the Forum. It's also very popular. And then you can see that there are other service providers like the Asian Domain Name Dispute Resolution Center, the Arab Center, the Canadian International Dispute Resolution Center. So you can choose as the trademark owner who's going to go after the domain name registrant, which service provider is best for you based on any factors that you choose. So you might choose based solely on cost. You might choose the Asian Domain Name Dispute Resolution Center because it's focused on Asia. You might choose WIPO for its stellar reputation, et cetera, et cetera. Okay, so the next thing that occurs is that we get started. So we would help the client to file a complaint. So here, our client, Orion Hotel, would file a complaint. Let's say we choose WIPO. We'd file a complaint with WIPO against the domain name registrant. Then we would send it to WIPO, and WIPO would send the complaint to the registrant, who's now called the respondent, and to the registrar. So for example, to GoDaddy or whoever has registered the domain name. Once the respondent receives the complaint, they can file a response. And once that part of the procedure is done, then the provider, here again, we'll pretend it's WIPO, would appoint a panelist. It can sometimes be one panelist, sometimes you can ask for more than one panelist, it depends. Then the provider will render a decision, and then the provider will communicate that decision to the registrar. So let's pretend it's GoDaddy, who will inform the parties of the date of implementation of the decision. So this is a very straightforward procedure. Excuse me, my voice is a little dry. So this is it's straightforward. It is very easy for clients to understand. It occurs very quickly, so we often recommend this procedure. So what do you need to prove for a UDRP complaint? So if you are the trademark owner, you need to prove that the domain name is identical or confusingly similar to your trademark. So here, we would need to show that, we own the trademark, our client owns the trademark for Orion Hotel, that someone else registered orionhotel.net, which is identical to our client's trademark, or that someone registered Orion with a Y, hotel.com, which is confusingly similar to our client's trademark. Then we'd have to show that the registrant has no rights to the domain name. So here we would show that the web pages that the registrant has created are not to promote their own Orion Hotel. They're trying to take bookings from our client. And then we would need to show that the domain name was registered in bad faith. So we would again show they've made their domain name look like our client's website. They're trying to confuse consumers into booking rooms on that hotel, on their website. And we would need to show all of these with enough sufficiency that we would win the case. So what are the benefits of the UDRP? As we've been saying, ADR tends to be less expensive. Here, the costs are generally about $1,300 to $4,000 in arbitration fees, depending on which forum you choose and whether you choose one panelist or 3 panelists. Then you have your legal fees. And with regard to legal fees, you have better control over the legal fees than in a court case. So there won't be a surprise counterclaim that your client has to prepare documents relating to. There won't be a motion to compel the discovery of documents, things like that. So you can control your costs much better in an ADR case. It's generally faster, as we've been saying. And in the case of UDRP decisions, there are searchable decisions. So you can look up what has happened in past cases, determine the strengths and weaknesses of your own case based on those past decisions. And these searchable databases also give public notice of an infringer's identity and actions. So this has 2 helpful consequences. One is that if you are preparing a UDRP complaint, you can search the databases, find out whether this is a serial infringer, and you can put that into your own complaint to show this person keeps doing this. Again, this shows he or she has bad faith. And it's also a bit of a public shaming. So, the infringer's name will be out there when you search their name. These decisions will come up. So it has a bit of a deterrent effect, I would like to think, to stop the infringer from doing this in the future. So some considerations that you need to think of when you're starting a UDRP rather than a court case. One of them is the remedies. So the available remedies are cancellation of the domain name or transfer of the domain name to the complainant. So we generally tell our clients that they should opt for transfer of the domain name to themselves, because if we just ask for cancellation, you can end up in a situation where someone just grabs up the domain name right after it's canceled and you have to start this procedure all over again. So transfer is usually more, is ideal. Not available in these UDRP cases, of course, is monetary damages. So if you needed to try to get damages back from the infringer, that's not going to happen. And injunctions, so if you needed to tell the infringer to stop doing something that's not related to canceling or transferring the domain name, then that's just not going to happen in a UDRP case as well. So you just need to think about these things before you decide how to go about it, but UDRP is often the best choice. Okay, so here's a second example. So if we have a foreign client who enters into a franchise agreement with a Thai franchisee and it licenses its trademarks to the franchisee, everything is going well. The restaurant is has lines out the door, gets rave reviews. However, 3 years later, the Thai franchisee stops paying the royalties, but continues to use our client's trademark. So now what are we going to do? The client may want to go to court, or they may want to try arbitration. They may be reluctant to start a case in Thai court because the pleadings will be in Thai and they won't be able to read them. They'll need to have them translated. They may not be familiar with the Thai court practices. They may be worried about the costs. They may be thinking they don't want to come to Thailand. They'd rather go somewhere that's more easy to get to. So we may discuss arbitration. So how does arbitration come up in these cases? Well, generally arbitration would come out at the outset when the parties are entering into their franchise agreement. So in the franchise agreement, they would choose an arbitrator and they would have an arbitration clause. So of course we have the Thailand Arbitration Center, our kind hosts. We have the Singapore International Arbitration Center, the Hong Kong International Arbitration Center, or many other different international arbitration centers that they could choose. And they would put this into their agreement. So we saw WIPO's model arbitration clause. This is the Thai Arbitration Institute's model clause. So this goes into the franchise agreement, and then the parties are all set up to do arbitration should they wish to do so. So we've gone through some of the benefits of arbitration. I'd like to kind of, say some of these again. Of course, the confidentiality is extremely helpful in these cases, especially when you're dealing with trade secrets or other IP that's very sensitive. Again, the arbitration can be more convenient or maybe equally inconvenient to both parties if the case may be everyone has to travel instead of one party having to travel, kind of evens out the convenience. The parties may be able to choose the arbitrator, as we were discussing. And importantly, with certain types of IP rights, for the IP owner, there will be no risk to the validity of their IP rights. So if you go to court, for example, with a patent case, there could be a risk that your patent validity could be challenged, which will not occur in arbitration. So it can be less risky. Okay, so considerations about arbitration. Discovery may be limited, more limited than in some courts. So, we all know the US has extensive discovery. That's not likely to be the case in your arbitration proceedings. And the enforcement may be more difficult in some countries, although this is improving. The enforcement of arbitration decisions can be slightly difficult, so it's something to consider. Okay, my last example, and this frequently occurs here in our office. So let's pretend that we have a client who produces makeup, and the client discovers that counterfeit makeup has been sold in Thailand. And our first step would probably be to send a cease and desist letter. And the infringer, in this case, refuses to comply with the demands in our cease and desist letter. They are still selling the makeup. Perhaps they don't even reply. We scare them off with our letter. So what do? So in this case, we would suggest mediation at the DIP. So Vaowdao already went through these stages, so I will just quickly go over them, but we would submit a letter, the DIP would get the parties together, and then hopefully we would be able to settle the dispute. So this is often a very good practical solution to our issues with infringers. So the benefits are inexpensive. So of course we learned that it's free before the DIP, and then we have our legal fees, but they're very much less than they would be if we were in court. It is fast, excuse me, and often the infringer feels less intimidated and may feel more cooperative if they're invited to do mediation. It's not as scary as a court case. They may feel that having some meetings is better than having to go before a judge. So some considerations for mediation would be that the infringer cannot be compelled to participate, as we talked about, and the parties may not come to an agreement, so the parties may end up in court after all. So this could lead to mediation being a delay in the eventual start of a court case and some added legal fees for attempting mediation. However, we find that it works quite well, so we do recommend it often when parties look like they may not be able to resolve this through correspondence alone. Then we will go towards mediation before we go towards litigation in many situations. So that is all I have today, but I'm happy to take questions, after this about, and I'm happy to talk about my experiences.
Okay, thank you very much, Michelle. That's reflects what is going on in the private sectors, and your experience has told us that we have very good examples of how the IP dispute could be resolved. Let me wrap up what the three speakers have addressed this forum before I would invite the speakers to answer the question and also wrap up what they have left or if they have anything to add to their first speaking. We seem to agree among the three speakers and also myself that arbitration of IP disputes could be a good alternative dispute resolution mechanisms when it comes to solving issue of IP disputes. However, there are some issue remains whether one type of IP dispute could be better resolved through this channel than to other channels, like going to the police, going to the court. Because as Michelle has said, it seems like in some remedies are not available via the ADR system. For example, you can't get the injunction from the court. You can't arrest the people who are deliberately violating the IP rights. In that, if you need that kind of remedies, perhaps you need to go to the official channels, like going to the police or file the lawsuit in court. And also, I think the most important thing for enforcing IP rights is to have remedies like compensation or damages, which I'm not sure whether the ADR would be the better option if you seek compensations or remedies, because as we know that the ADR requires the free will of the party to participate. That means that both parties must be agreeable to go to the ADR system. But that's unlikely. That's likely to be in the case of where the two parties are on the equal footing. For example, you see the two companies claiming over similar or identical trademarks, for example. If they want to resolve who actually owns the trademarks, or in case of two copyright owners claiming for the same piece of work. In that case, if the party agree then to find a solution, then ADR would be the better option. But if you try to catch a small guy, the copycats who deliberately infringing your copyright works, downloading music and movies, then perhaps you can't take them to the ADR system and then say we will resolve the dispute via this channel. In that case, perhaps it might be more suitable if you go to the court and seek an injunction to stop them. I think maybe now I will, before, if the participants have questions, maybe we will suggest you to write it down in the chat forum so that the speakers can pick up and answer your questions. Now, I think we have a few questions now. Perhaps I would invite each speaker to wrap up their speaking and also to answer the question, if any. May I go back to Chiara to talk in the second round. Chiara, please.
Thank you very much. In fact, I see a question in the chat box from Kowit Somwaya on the settlement rate of WIPO arbitration. Why is it lower than the settlement rate in mediation? That's true, and that's because arbitration and mediation are very different procedures. So in mediation, your objective is to settle, so to find the settlement and to find the agreement with the other party. And in 70% of the cases handled by WIPO, the parties are able to do so. Arbitration is a very different procedure. So in arbitration, the parties are not trying to reach a settlement. In arbitration, you have an arbitrator which is going to make a decision on a dispute with a decision which is called arbitral award. So what the parties are really looking is not to find an agreement, but to get a favorable decision for them from the arbitrator. But what happens is that even if arbitration is not usually thought and parties do not start arbitration to settle, even during arbitration, parties sometimes manage to find space for settlement. And this can be done, for example, on the side of the arbitration. Sometimes it has happened that they ask you to stay the arbitration proceedings, so to stop, to interrupt the proceedings, and the parties engage in direct negotiations. Or sometimes, and we've seen a couple of times, is that the parties try to mediate and find an agreement. They couldn't find it, so they started the arbitration to have a decision from the arbitrator. And then they actually realized that they could have found an agreement. So they decide to interrupt, to stay the proceedings in arbitration, and they do manage to settle. This is something that we have seen, but basically the reason why it's lower is because it's a different procedure where the parties are not looking for settlement. And even then, sometimes they still manage to settle. And then I just wanted to make maybe a couple of remarks on the type of disputes which are more or less suitable for ADR. I completely agree. I think that ADR is suitable for most intellectual property disputes, but of course not all of them. So for example, if you're really dealing with counterfighting, for example, or where the other party is not collaborative at all, then maybe mediation is not the best procedure, because in mediation it takes both parties good faith and goodwill to find a solution. So if the other party is not on the same page, of course maybe for litigation in those cases may be a better option. For example, if you're trying to set a precedent, a legal precedent, then you don't want the confidentiality, you want a public proceeding in court. So in those cases, maybe ADR is not the best option. What we see that is that, however, mediation and arbitration can be suitable for more cases than one is expecting. So for example, it's quite interesting, infringements. So infringements used to be a very, I would say, minor part of our caseload. So the majority of our cases, as it been in the past, you know, contractual cases for a patent license, the breach of contract, and then a very few infringement cases. We have seen that in the past years, the number of non-contractual cases, and the majority of those are infringement cases, is almost half of our caseload. So a huge increase of infringement cases being mediated. And sometimes it takes, again, two parties to be collaborative. It was quite interesting because in the mediation, they realized that, for example, one party that allegedly was infringing, say, someone's trademark or copyright, actually had access to some markets, for example, in some countries. So sometimes even the parties were able to maybe start a collaboration during the mediation. Concluding, for example, a license. So this has happened not in all cases, but in a few cases. So I thought it was worth mentioning. And for arbitration, so it's true that, again, copycats, maybe the ADR could not be the best option, but for example, for injunctions, there is also the possibility under the WIPO arbitration rules to request interim measures from the arbitrator as well. And usually they're really complied with because it affects really the proceedings. So that's something that it can also be done in arbitration. And I'm scrolling down the chat box to see if there is any more questions. By the way, I'm happy to share the slides, so of course feel free to circulate them. Otherwise, I'll leave the floor to Vaowdao or Michelle.
Maybe there's one question that perhaps you can help to answer. Question 3 just come up now. Dominant dispute and ODR, how do you deal with confidentialities? How is it possible to control all data transmitted over the internet during a hearing? Moreover, who can control the provider of online platform where the hearing is held? I think this is very interesting and very good questions. Would you be able to address this?
Yes, so for the UDRP, which is also WIPO is one of the providers, the proceedings are public and decisions are public. So confidentiality is not really feasible for this type of procedures.
Yes, I think the confidentiality is very important, particularly if your subject matter, your technology is sensitive in nature. For example, if you're the owner of trade secret, you are alleging someone infringing your trade secret, and you want to take the case to the court or the ADR system, you would ensure that at least you can keep the details of your trade secret. But at the same time, you can enforce your trade secret rights against that person. It seems like you are saying that the WIPO ADR system is not suitable for anyone who try to enforce the trade secret or breach of confidence.
I was actually referring to domain name disputes under the UDRP. So in those cases, they are not confidential. So also the decisions, they are public. But otherwise, in mediation and arbitration, no, we have a very strict confidentiality code, which really preserves the confidentiality of the proceedings itself, of the result, and also of all documents and declarations made during the proceedings. There are also some, I would say, very specific features. So for example, it is even possible to, nominate and select a confidentiality advisor in a case. This has not been used many times in the past, but it's a tool that we provide. And in general, for mediation and arbitration, and we have seen some trade secrets cases as well, confidentiality really is of the essence. And again, of course, when you have confidential information at stake, but also we see that parties have a strong interest in confidentiality because they just don't want the dispute to be on the press. So really for reputational reasons, both because they already have an established reputation, or also because they're actually starting their own business, and they would actually make it more difficult to get, for example, investors to pitch in. So confidentiality has been a really primary consideration, and it's dealt with very strictly under the WIPO rules. I cannot hear you. I think you are on mute.
Forgot to unmute, sorry. I'll say that again. Sorry everyone. The last question is addressed to you. Is WIPO a signatory to the equal representation in arbitration pledge in order to promote diversity in arbitration? Would you answer that?
I would have to double check if it's either WIPO or the Arbitration and Mediation Center that has signed it. I believe so, but you know what? I will check right now and get back to you on that.
Okay, all right, thank you. Then I would invite Kun Vaowdao. Kun Vaowdao, you still with us? Kun Vaowdao Club? Yeah, Kun Vaowdao, could you be able to answer the question? There's a question for you. May I ask the speaker from the DIP, this moment DIP has developed policies. Has DIP provided mediator for DIP's ADR or not? Then the questions continues. If provided, how to apply under the DIP policies to be a mediator such as THAC or court?
Yes, now we have a mediator that is from the specialist from the DIP, such as the copyright specialist, the patent specialist, and the trademark specialist. We have 3 mediators, and the other IP issue, if the dispute come into our office, we will designate the person who is suitable for that dispute. For the arbitration, we also have the arbitrators, about 44 arbitrators, but now we will get more arbitrators, and the new one, because that list of arbitrators is not up to date now, and we will search for the person who is appropriate for the for being the arbitrator in the future.
Kun Vaowdao, I have a question for you too. Do you think, in your opinion, that would you suggest Thai parties to use your ADR system instead of going to the IP and IT court, compare in every aspect? For example, whether it's more cost efficiency, more speedy, quicker to resolve the dispute by using the DIP system than going to the court?
Yes, we suggest the parties to use our ADR system because it is effective way to resolve the intellectual property disputes or the related IP dispute, and it is very time consuming, less time consuming for the court, and of course it is as I said, it is cheap than the to go to the court, and we have the specialists for the IP disputes at our department. So I recommend the parties to use ADR system before going to the court.
Put this into practice. How would this? How this gonna work? For example, if there's a dispute about the validity of the trademark registration, and if someone contests the issue in the Board of Trademarks, and then they don't have a good result, the decision go against them. Then if they want to revoke the board decision, they have to take the case to the IP court, right? IP and IT court. How would you ADR system intervene during this process? Would that person, instead of going to the IP court, they decide to go to the DIP ADRs and ask the ADR to resolve the issue? How is that going to work? And if that is possible and ADR have a decision, would your registrar, the registration official, apply or implement the decision of the ADR? Would you give us the clear picture, please?
Yeah, thank you for the question. If the decision of the trademark committee does not satisfy any party, the party can bring his case to our ADR system, and in the future we plan to extend the scope of ADR to implement mediation for trademark opposition and invalidation in the near future.
Okay, so that means that the party would have an option instead of filing the case in a court, so they can go to the DIP ADR, which is cheaper, and perhaps apart from paying Michelle's lawyer fees, they don't have to pay anything. Okay, now I move to Michelle. Michelle, there's some question that perhaps you can help to answer, or you have anything to add to your first round of the presentation, please.
Sure. So I saw the very good question from Jackie Lai, who asks, so is it natural selection that willing infringers tend to yield and to transfer the domain name to claimant readily? Otherwise, they just do not respond to UDRP messages at all. Damages and injunctions are not available under the UDRP. So yeah, this is a really good question. If we have a very blatant bad faith infringer, in many cases, they will simply not respond to the UDRP complaint. And yes, in that case, assuming we have a strong case for our client, then we will win the case and the domain name will be transferred. Sometimes these infringers, though, they're making a lot of money on their websites, and they get angry, and then they will file a reply. But again, they often are unsuccessful when they're just completely bad faith infringers. As far as cases where it may not be so clear cut, so you can imagine a case where our client owns a trademark in Thailand or Southeast Asia, and they find someone else who has a domain name using that trademark. and that person owns that trademark, say in the United States, they could use the UDRP procedure to adjudicate that case. And in those situations, it will be a robust back and forth between the parties. And it will, it's useful in those cases. I would not say that you necessarily have to go to court for those cases. The UDRP procedure is robust enough to handle real, legitimate cases between two IP owners. So it's not necessarily just for the easy cases. You can bring hard cases under these procedures. So that, but yes, and as Jackie notes, there's no damages or injunctions. So in those cases, you just have to be willing as, you know, as the trademark owner to forego those and just want to settle it by, you know, only getting the domain name back or getting it canceled. So that is the case there. Let's see, I think there was, oh, the question about franchise-related disputes. So the question is, with respect to the franchise-related dispute with a Thai franchisee, is there a special regulatory reason or advantage for choosing a Thai arbitration institution for the arbitration? Usually the franchisor would choose arbitration in its own jurisdiction or arbitration in a neutral country. So based on my practice, I do not see a special regulatory reason or advantage to choosing a Thai arbitration institute. So we frequently will tell our clients to choose the arbitrator that meets their needs, you know, in the best way. So if Singapore is better for the client because they fly there all the time, and you know, we may recommend Singapore. If Hong Kong is good for the client because one of the parties would like to have dealings in Chinese, then we'll do Hong Kong. So no, there is not an advantage to choosing or a regulatory reason for choosing the Thai Arbitration Institute.
Okay. Thank you very much. It seems like, oh, there's one question left. Maybe I go back to Chiara. It seems like you have an answer to the question about the ERA. Chiara, please.
Yes, so they was joined by WIPO, and I will share the link on that.
Can you elaborate what it means, the equal representation in arbitration? Some of us may not know about this.
So that relates to, for example, gender and diversity, and then there's also something that we take into account when we select, for example, mediators or arbitrators in a specific case. The moment of the selection and the appointment of the mediator, I wanted to mention though, it's not just the institutions, also WIPO choosing and selecting the mediator. At the same time, we really want to give voice to the parties' requests. Sometimes, for example, we do have parties' requirements and requests for a mediator and arbitrator, for example, to be of a certain nationality, or not to be of a certain nationality. For example, they often ask for nationality different than those of the parties, or for example, someone that is actually able to deal with certain cultural differences, of course, languages, geographical location. So these are also feedback that we really take into account when we propose candidates to the parties as well.
Okay, thank you very much, everyone, every speakers, and also everyone who participated in this webinar. I think we have a very good discussion. We have different various perspectives from international organizations, government officials, and also the private parties. Thank you all the speakers. I don't think we have any more questions to address, and also unless if the speaker have anything to add to the presentation. No? If not, then I will call it a close. And I thank you everyone for participating, and everyone has a good day. Thank you.
Thank you.
Thank you.
Thank you very much, everyone.
Much, everyone.